In. Good afternoon to everyone. My name is Angus Gillies, and as you can see from the slide there, I'm an associate in the insurance department in BTO Solicitors. I'm also part of BTO's dedicated fraud team, and I'm one of the fraud champions. And one of the parts of my job is to help colleagues develop fraud strategies on specific files and to identify trends and keep the team updated on those things. So to give you a kind of flavour of the kind of things we're dealing with just now, we're currently investigating a few garages in the Glasgow area who have been presenting fraudulent repair invoices. We're currently investigating a suspicious credit hire company. I've personally represented a client who was the victim of fraudulent misrepresentation when a credit hire company induced her to sign a credit hire agreement which she wasn't aware of, wasn't made fully aware of the terms and conditions, and she was the victim of quite a sophisticated spoofing operation. We've also dealt with fraud rings operating north and south of the border, and myself and partners in the insurance team, Stephen Bryceland, we recently worked on a number of related low velocity incident claims, which were recently abandoned, and we recovered expenses for our client on that one. So that's just a flavour of the kind of things we're dealing with just now in the team. So there's a lot going on in the fight against fraud, and we're laser focused on these issues. And quite frankly, we have to be. Fraudsters are becoming more sophisticated, and pursuers in general are much more clued up on how to artificially inflate the value of their claims. And moving on to the next slide, I think these figures really speak for themselves. As we enter into another economic recession, I think we can assume that these numbers are going to increase. So we've got there 1.1 billion of fraudulent claims detected in 2020, and potentially a similar amount of undetected fraud every year. And that's quite staggering. And in Scotland, as you're all probably aware of now, that we have qualified one-way cost shifting, as we'll come on to discuss. But we don't have the whiplash reforms and associated cap on damages payments in Scotland, as you do in England, which makes this jurisdiction particularly attractive to organised fraud and those wishing to exaggerate or present fraudulent claims. So what do we mean when we're talking about fraud? It's sometimes to get back to the very basics. So Erskine, an institutional Scottish writer on Scots law, defined it as a machination or contrivance to deceive. And that's what the courts will refer to, and that's the definition the courts will use when they're dealing with a case of alleged fraud in Scotland. So fraud is proved where it's shown that a false representation has been made knowingly, without belief in its truth, or recklessly, carelessly, whether it to be true or false. There's the ABI general insurance fraud definition. So we have fictitious losses, incidents or injury. So claim losses where the incident did not occur. Staged accidents, well, we all know what they are, where a claim is received in respect of damages, but it's been caused deliberately. So for example, staged accidents and motor claims are something we deal with on a regular basis. And the third grouping is really the type of claims and type of fraud that we deal with most often at BTO. So material misrepresentation or exaggeration of loss or personal injury. And more often than not, that's involving a claim of chronic pain or a claim which has been artificially inflated by a psych element, for example. And then we have proven fraud, where it's established that the fraud has taken place after a trial, or a suspected fraud, where fraud has been suspected on a claim, but we've fallen short of being able to establish that in evidence at court, or in fact, cases where the claim has actually been genuine and it hasn't turned out to be a fraudulent claim after all. So how do we go about identifying potential fraud or dishonesty? Well, those of us who deal with these claims on a daily basis sometimes just know it in our gut. It's instinct. It becomes instinct after a while. There's something strange in the file that just doesn't add up and it warrants further investigation. So certain behaviours taking road traffic accidents as an example, policy recently incepted, the policyholder eager to accept liability can be a red flag. Accident occurred in a strange location late at night. So the case is I referred to at the start, where there was a suspected fraud ring operating north and south of the border, and we would get cases, the road traffic accident occurring in a strange location in Glasgow or Paisley, for example, very late at night, involves short-term hire, and the next day the hirer would go back to England and never be seen again. So those type of behaviours are obviously are red flags and warrant further investigation. High occupancy, damage and inconsistency in previous claims, all of them can be red flags and warrant further investigations, and these are all things that you'll be familiar with. Perhaps not, some of you might not be familiar with how we deal with low velocity accidents in Scotland. There's traditionally been a lot of myths surrounding how we go about defending low velocity accidents in Scotland. And I've heard before from some of our clients in England that they have the impression that they simply can't be defended in Scotland and it's not worth the time attempting to do so. That's thankfully not the case. But convincing a court that a road traffic collision was so minor that no injury could have been sustained on the balance of probabilities is not always straightforward. You're likely going to need engineering and expert medical evidence of the opinion that the occupant displacement and injury were unlikely, but also some additional factor or piece of evidence which can be used to undermine the credibility of the pursuer. And the case I referred you to there, Spencer against Barron, is one we often refer our clients to when we're discussing what's needed to defend a low velocity accident. It's a Scottish case and from Edinburgh Sheriff Court, and involved a low velocity impact collision. The evidence in this case was that the accident occurred at approximately 3 miles per hour. There was no damage, and the collision was described as being a nudge at the rear of the pursuer's vehicle. The defender led evidence that the accident was unlikely to have caused any injury to the pursuer, so experts, medical and engineering evidence. However, the pursuer maintained that she did sustain soft tissue injuries as a result of the accident. Now, ultimately, the court did award damages to the pursuer and found her to be a credible witness, and that was the key point. Whilst the engineering and medical evidence raised serious doubt as to whether the impact could have caused injury, the fact that she was a credible witness and gave a credible account of her injuries was ultimately the thing that tipped the balance of probabilities in her favour and resulted in her getting a damages award. So in this case, the pursuer was basically beyond reproach. So she was a local magistrate. She was involved in charity work and the Prince's Trust. She was a counsellor at Women's Refuge and considered to be an upstanding member of the community by the sheriff. So it's going to be very difficult to undermine that particular pursuer's credibility. And in light of that, the court was prepared to accept her account that she sustained injury as a result of the accident. So that case is a good example to illustrate what's required when we're realistically going to defend a low velocity accident. You're probably going to need that additional factor, something that we can hang on to not only demonstrate that it was a low velocity collision, there was no damage, for example, occupant displacement was unlikely, but also something that we can use to undermine the credibility of the pursuer. To give you an example of a case where I recommended to my clients that we run a low velocity accident claim, we had all of those ingredients, no damage, very low velocity impact, but also the pursuer's own medical expert confirmed in the medical report that he did not find the pursuers to be credible witnesses and did not give an accurate account of their injuries. So in that case, that was perfect to recommend to my clients that we proceed, given their own medical expert did not find them to be credible witnesses. I forgot to say at the outset as well, if there's any questions, please feel free to chip in whenever you want to. I'm trying to make it as informal as possible, and I'll keep it fairly brief. But if you want me to expand on anything, I'm happy to do so. So other Other pieces of evidence that you can be presented with in a claim which can raise your suspicions. We often deal with taxi driver claims, so we will get quite often these accounts which have clearly been drafted by themselves or by an accountancy firm that we've never heard of, for example. And the profit and loss accounts that have been produced by, for example, taxi drivers are just highly suspicious and don't look very professional at all. So that in itself can warrant further investigations, and we've had cases like that in the past. When it comes to injuries, obviously, if the injury prognosis seems completely excessive in relation to the accident circumstances, then obviously we're going to have to get our own medical expert to challenge that. If there's a substantial psych component, which we are seeing much more regularly now, if there's a psychiatric component which needs to be challenged, that needs to be considered as well. Sometimes you'll get, in road traffic claims in particular, poor quality medical reports, where it just seems like it's been a kind of desktop report, if you like, where there's been no consideration of medical records at all, and sometimes the pursuer hasn't even been physically examined. That absolutely needs to be challenged.
Angus,
so the key to the
Angus, it's Stephen here. Just on that point about medical examinations, I suppose it's maybe worth just thinking about that for a second, in that over the last, well, what is it, 2.5 years now since the first lockdown began, it's really become the norm in many cases that there won't be a face-to-face medical examination. What sorts of things would you be looking for in medical evidence to make a judgment call about whether you think, in the absence of a physical examination, that something is satisfactory or not?
Well, a lot of the time it depends on whether we know the expert to be somebody who we consider to be a good expert, and we obviously, because we deal with personal injury claims on a daily basis, we know which experts can be relied upon and which ones are sensible. Sometimes you'll get one from a firm and a medical expert that we know is a bit, shall we say, slapdash, and kind of churns out reports to help certain firms just basically farm their personal injury claims. And those will quite often have fine, fair enough. During lockdown, we couldn't have physical examinations of claimants, but there will also be that additional aspect of there being no medical records considered. The excessive, the prognosis is based on kind of vague reasoning, and those sort of things are the things we have to look for, and especially
at the end of the day, we wouldn't rule out the prospect of settling a claim based on evidence that had been obtained remotely, but it's ultimately just about a consideration of the quality of that evidence. Absolutely, and the background to it.
Yes, absolutely. I don't think there's much reason now not to have somebody physically examined. That's something I would definitely want to insist upon, especially when I have concerns, fraud concerns. That's something we always insist on. And there shouldn't be any real reason that can't be carried out in person. But again, it comes down to whether we know the expert, and whether we know the expert to be somebody who's credible. And we sometimes we get reports from experts we use ourselves, and if I had experience of them before. But quite often, the ones that raise our suspicions are the ones that we know to be associated with firms who are involved in fraudulent claims, and the quality of the reports just aren't very good. That, for me, is the red flag that you're looking for.
Great, thank you.
No problem. In terms of investigations, what we generally tend to do is, obviously, we take a proactive approach. So we have a number of tools at our disposal under court procedure to recover evidence by way of court order. So often you'll see us recommending that we obtain pursuer's medical records by way of specification of documents, which is something that we can serve upon the pursuer's GP and his treating hospital to recover his medical history. We also have other things such as specification of property if we need to inspect something, or we need to recover items which have been claimed, to inspect them ourselves. So those are the kind of things that we do on a daily basis. And generally speaking, you're looking to cast your net as wide as possible if you are looking to, if you have concerns about fraud, but you don't quite have that killer blow piece of information, but you want to investigate whether this is indeed a credible and genuine claimant. So this is especially the case when you're defending suspected staged accidents and low velocity incidents and phantom passengers. You're looking to build up a body of incriminating direct evidence, but also indirect and circumstantial evidence pointing to suspected fraud or casting doubt on the credibility of the pursuer. So you'll be looking to see what's revealed through your usual cache and IFIG and IFB searches, for example. Speaking with the insurers involved in the previous accident is something we do on a regular basis. If there's a history of previous accidents, sending again off our DPA requests, investigating previous accidents and seeing whether there's any concerns on those previous accidents, that can be highly valuable. In terms of court procedure, we're looking to gather as much evidence as possible through the use of, for example, the specification documents procedure that I referred to earlier, and speaking to the relevant witnesses, considering surveillance, intelligence reports, and things like that. And one of the most valuable components of our claims handling is the intel that we share with our clients and also other insurers in the Scottish market. We've got a good network of contacts within the industry, and this helps us greatly with our own investigations. I referred there to a case of BTO against RK and UK Insurance. This was a case where the credibility of the pursuer was undermined, actually destroyed, during the proof, which is the name we call the civil trial in Scotland. So he was ambushed with basically Facebook printouts showing that he knew the defender, and all of this pointed to the accident being a staged accident. Ultimately, the case ended up being dismissed, and the sheriff in this case recommended that the case be referred to the Procurator Fiscal due to the perjury which had been committed by the witnesses and the attempts to defraud the insurance company. So you never know, as quite often fraudulent claimants are very aware of social media and will not post anything incriminating, but it's always worth having a look, because sometimes you will get something that's pretty damning, like they did in that case. So once you've done your investigations and you've got all the evidence that you can possibly get at that stage in your case, you have to think about tactics. So you have to consider if the evidence is strong enough, the case should run to a civil trial. Do you have enough that you can, for example, if we're in a position we're speaking to our clients, do we have enough that we can recommend to our clients that there are reasonable prospects of success? When should you disclose each piece of evidence, if at all? This is something that has to be considered carefully. Should you simply lay it all out once you've done your investigations, or should there be more of a drip feeding? And once you get each piece of evidence pointing to fraud to raise doubt in the claimant solicitor's mind, these are things that all need to be considered, and it all depends on the circumstances of the particular claim. Do you need more information? One of the challenges that you will people working in insurance companies will have, claims handlers, is how to investigate fraud, or whether you can investigate fraud fully when you're trying to comply with the compulsory pre-action protocol in Scotland. Now, you have 3 months to investigate liability under the protocol, and that can be quite challenging if you have significant fraud investigations to carry out. So you'll have the competing interests of wanting to investigate suspected fraud, but also wanting to adhere to the pre-action protocol to save expenses if it's possible. One of the things that I recommend sometimes is where that's a concern for some of our clients' claims handlers when they're reaching the 3 months deadline, and it's just not been long enough for them to investigate the fraud concerns that they have, is to perhaps write to the other side and ask the pursuer to clarify certain matters and highlight to them that the concerns that you have at that stage and why it's quite reasonable that you need further information before you can arrive at a liability decision. Perhaps you can ask for example, an informal extension of this 3-month period, appearing reasonable in your correspondence in case it's referred to later on in court. But unfortunately, there's not much more you can do other than try and get most investigations done within that three-month period if you want to adhere to the pre-action protocol, and then take a decision as to whether you want to settle it. We now, like I said, have qualified one-way cost shifting in Scotland, but there are exceptions to the qualified one-way cost shifting rule. So the general rule is that no expenses will be made, and no expenses awards will be made against the pursuer. However, this protection is removed where the pursuer or their representatives make a fraudulent misrepresentation or act fraudulently in relation to the claim, and they behave in a manner which is manifestly unreasonable, or they conduct proceedings in a manner such as to amount to an abusive process, as under section 8.4. Now, unfortunately, the courts in Scotland have not yet published an authoritative written decision which gives us any guidance on how and when these exceptions will apply precisely. But the exceptions are there, and they include exceptions to quox, where the quox protection for the pursuer is disapplied where there has been fraudulent conduct. We should use them to the best of our advantage, even if that is just a case of threatening and using the threat of quox being disapplied where we have suspected fraud as leverage in our negotiations. We will wait and see how the courts will interpret and apply quox and the fraud exceptions in due course. A very recent case which brought these issues to the fore was the case of Cossey against Buccleuch Estates, which is in the Outer House of the Court of Session. In this case, the pursuer fell into an open manhole cover, and that's how the accident, her injuries were sustained. She claimed that she sustained injury as a result, which resulted in persistent pain in the right-hand side of her body, affecting her shoulder, arm, wrist, and leg. And she claimed that she suffered an exacerbation of her pre-existing somatoform symptom disorder. And she claimed for solatium, loss of earnings, pension loss, and necessary services. And the sum sued for amounted to £1 million, so a very high-value claim. However, the various descriptions of the accident circumstances provided by the pursuer during the trial were found by the court to be inconsistent. The pursuer was 5'2", and she described both legs falling into the manhole, and that she had to arrest her fall by putting her arms out to the side, and that her feet did not touch the bottom, despite falling to the depth of her chest. Now, the depth of the manhole was measured at just under 2 feet. Now, video footage of the manhole was shown at the proof, which clearly showed that the manhole was nowhere near as deep as she had alleged, and she was unable to offer any explanation for her inconsistencies to the court. She had a lengthy history of medical complaints which predated the accident. From at least 1994, she had been complaining of pain and other issues associated with her limbs for which no organic or neurological cause could be identified. This included pain in her right ankle and her right leg giving way. Now, the extensive pre-medical history suggested strongly that her problems appear to be rooted in pre-existing somatoform disorder, which is a chronic pain condition. And the defender's neuropsychiatrist, Professor Alan Carson, who concluded the accident did not exacerbate her pre-existing symptoms, was preferred by the court to the pursuer's own expert. So ultimately, in cases such as this, where you have a chronic pain claim, the medical experts and the court rely heavily upon the what's been described to them in terms of the injuries by the pursuer and their subjective perspective on what's going on with their injuries. In this case, Lord Turnbull and the Outer House did not consider the pursuer to be reliable or credible, and the damages were awarded at under £5,000. So a far cry from the £1 million which was originally claimed in that one. And what's important to note is that this court action was raised pre-qualified one-way cost shifting being introduced in Scotland. So the pursuers in this case, sorry, the defenders in this case had lodged a tender of 15k. Obviously, the pursuer failed to beat it. So that meant that the defenders had cost protection, so they're entitled to the costs from the date of the tender, which included the very significant costs of running the case to the trial or the proof. Now, this wouldn't be the case if it was raised post-Quox, because after Quox was introduced, the expenses entitlement post-tender for the defender is 75% of the damages awarded to the pursuer. This is significantly less than what was awarded to the defenders here. So that's something to bear in mind. But I think possibly it could have been argued that one of the fraud exceptions in this case may have applied, and the Quox protection could have been disapplied had that been established, but we will never know. So we'll just have to wait and see what happens when a similar case is brought to trial under the Quox regime. So I thought I'd give you a flavour of the kind of stuff that we've dealt with recently. So this was a case that was dealt with by my colleague Karina McShane. It was a personal injury case, and as a result of the accident, the pursuer claimed that she was severely injured. She was no longer to carry out her employment as a professional dancer as a result of the accident, and there was therefore a very significant loss of earnings claim attached to this dissolution claim. However, Karina decided to think outside the box. She looked on YouTube and found a video of this claimant dancing on YouTube post-accident quite vigorously and clearly not restricted in any of the ways that she claimed. When this evidence was presented to the pursuer solicitors abandoned the claim. So that was a good result, and quite a swift result, resulting in significant savings for the client. This was an example of a case I dealt with some time ago, where it was quite a very low velocity accident, but it was one of those cases where you had lots of additional suspicious heads of claim, such as the claim for a broken laptop and a phone, and I thought, hold on, this doesn't seem right at all. So I used some of the procedure I referred to previously, a specification of property. I recovered these items, and clearly the extent of the damage to these items did not correspond to the accident circumstances and the velocity of the claim. Now, when this was presented to the pursuer's claimant, I managed to settle the claim for a much lower amount than was being claimed. So sometimes it's worth digging a bit deeper on certain claims where you know something's not adding up. Now, this was a fantastic case that was run by my, defended by my client, my colleague, Lewis Richardson. This is a case where the pursuer claimed that he was unable to work due to ongoing pain and functional dystonia in his right thumb. And he claimed that his thumb was in a constant thumbs up position as a result of his accident-related injuries. He claimed this meant he could not carry out tasks which required two hands, so he was therefore unfit for work, quite clearly. He claimed that he simply sat around his house all day doing nothing, and he could no longer play games on his Xbox, which was his favourite hobby. So the claim therefore had significant value, quite a young guy. However, Lewis did his investigations and was very diligent, as he always was, and discovered that the picture quite wasn't as it was presented by the pursuer. He found a streaming site where he was playing games, and luckily he was captured on video after the accident using his right hand for various tasks. He was streaming on this gaming site for upwards of 12 hours. He was doing stuff like repositioning his headphones, drinking, eating using a fork, using a towel to dab his mouth. At one point, he turns his gaming chair upside down to effect a repair. He's wearing no wrist splint or anything like that. And he's drinking excessive amounts of alcohol. So again, clearly this person was involved in a fraudulent claim, and he was exaggerating the extent of his accident-related injuries. I've returned to this slide now. You can see him there flexing his muscles. Clearly his hand is not as injured and stuck in a thumbs up position as he claimed. That's the one where he's repairing his chair. Clearly there's no restriction at all. And the claim was ultimately abandoned, and Lewis managed to get expenses for that claim. So a good result there. And also to give you an example of a case which was dealt with only the other month, and this was a case involving an accident at work. The insurer claimed for £126,000 for salation, loss of earnings, loss of employability, services, and pension loss. His medical complaints were quite unusual. He lost consciousness on impact with the ground during the accident at work. And after that, he claimed he had back pain, headaches, and an intermittent tremor affecting his right leg. So he'd drag his right leg about and walking, I suppose, kind of like a zombie, if you like. He had several cognitive difficulties he claimed were attributable to the accident. And he claimed his thought processing had slowed down, and his concentration and memory loss had declined as a result of the accident. And he's saying he became really self-conscious about having to drag his right foot about anytime he walked anywhere. He becomes increasingly socially isolated, according to him, as a result of the accident. And he claimed he had symptoms of anxiety and depression caused by the accident. So again, quite a significant claim, significant in value. However, we have managed to obtain surveillance on this particular individual, and he can be seen doing a number of things which did not tie in with what he told the medical experts. So he was seen walking his dog, driving and shopping. He's seen going out, buying, loading his car with golf equipment and playing rounds of golf. And I believe that he played a round of golf just before he went to see one of the medical experts, where he claimed he was unable to do any of these things. So all of this was presented to our medical evidence, the surveillance, and our medical experts, our neurologist, had originally considered that the pursuer had functional neurological disorder as a result of the accident. However, upon seeing the surveillance, he commented that the pursuer was moving entirely normally, with no evidence of any disability. So in his view, there was only one conclusion to be drawn. And he commented in his report that the pursuer was malingering, presumably for financial gain. And he concluded that none of his testimony was reliable, and he'd been left with no residual disability after the accident. So he withdrew his original conclusions in his report and replaced them with an unequivocal conclusion that the pursuer's symptoms were factitious. So here he is playing golf, quite clearly has none of the issues that he claimed he had in terms of anxiety, depression, feeling socially isolated, and none of the physical symptoms of having to drag his right leg about and the restriction associated with that. There he is again, he's in the shop as well and playing another round of golf. The claim did have some limited value due to some minor orthopedic injuries, but certainly not the £126,000 that the pursuer claimed. An interim payment had been made of £10,000, which was ultimately accepted in full and final settlement of the claim. And now that's been disposed of, we are now challenging the CRU benefit certificate. So the important thing about the £10,000 is what that included the expenses of the pursuer solicitor as well. So I think we can safely assume that the pursuer solicitors made a loss on that one, and that was a good result. So that was just a basic overview of the position in Scotland, giving an idea of the kind of things that we deal with on a daily basis, and thereby hopefully giving you an idea of the kind of trends in the fraud arena that we're seeing and some of the challenges that we're going to be facing in the future. If you have any questions, we've got 10 minutes left. So if you have any questions, I'm happy to take them now, or if you want to discuss anything, you want me to expand on anything, I'm happy to do so.
Angus, it's Stephen again.
Hi there.
Thanks so much for that. That's really informative and helpful to get kind of a summary of where we're at, and to, obviously I know about the cases that BTO have been involved in, but it's really good to see them brought together and the results that we're getting. Just going back to the sort of current financial climate, historically I would have said in Scotland there was perhaps a bit more of a trend for opportunistic fraud, which was down the exaggeration route, where actually there is kind of a genuine accident in the first place. Do you think that that's where we're likely to see an increase if people are more financially challenged and are looking for ways to make money, or have you already been seeing an increase in more organised fraud across the marketplace?
Certainly, our work in terms of fraud will be dominated by pretty much by challenging those claims which are exaggerated, and that's definitely going to be the more common types of fraud that we deal with. But there's definitely an increase in the organised types of fraud that perhaps our friends down south are more used to dealing with on a daily basis. So, for example, the fraud rings I was referring to there that we dealt with involving the credit hire, that's something that we've seen in a number of cases now. And we're just really at the tip of the iceberg, I think, because I think there has been a lot of stuff going on in the background, and unfortunately insurers and law firms now have to catch up with all of that. And I think the organised element of it is much more prevalent than it used to be. And in fact, I'm absolutely certain of that. And like I was saying before, I think this is a much more attractive jurisdiction for those who are involved in organised fraud, given there's no cap on the damages awards for motor whiplash claims that you have in England, and now the qualified one-way cost shifting. And you can see that there's more business, and there's new firms opening up all the time, where we have more and more concerns about the authenticity of the claims that are being presented by these firms as well. And that's happening quite a lot, and the market's starting to become dominated by it. So yes, absolutely, both of those types of fraud are on the increase.
Hopefully the extortionate cost of flights to and from Scotland and hire cars at the moment might put some of these potential fraud rings off coming up to the airports for an overnight to try and set up their accidents.
That's a good point, actually. Yes, that's a good point.
Just one other question as well, just obviously from our experience, and we have worked together on cases. But how do you feel the sort of judicial attitude is towards these issues in Scotland? There is a little bit of a feeling sometimes that the courts here can be a little bit claimant pursuer friendly, and that that there is if you are challenging credibility, reliability, or the whole basis of a claim generally, you've got a bit of a mountain to climb to convince the judge to get on board with that. Do you think that remains as challenging as it's always been, or any changes?
It really depends on the court you're dealing with and the type of procedure. So I can understand, yes, absolutely, you have to have, if you're going to allege somebody's acting fraudulently, you have to have evidence, and you have to aver it, have it in your written pleading, your written defences, and set it out properly. And you have to be able to back that up with evidence. And I think that's fair enough, and which is why it's important that we do our investigations properly. So in that regard, absolutely, the court's attitude is always going to be, if you're alleging fraud, this person's a fraudster, you better have evidence to convince me that is the case. However, courts in general will be open to hearing that sort of thing. And sometimes you do get the odd sheriff or the odd judge who has seen a particular type of claim from a particular type of pursuer firm, and they are skeptical. And you can see that when you appear in front of them in court. I've experienced that on a number of occasions when I've been dealing with inflated credit hire claims, for example, in Glasgow. And the sheriffs there, for particular, are wise to it and will not be sympathetic, for example, to inflated credit hire claims. And I suspect that's going to be the case with fraudulent claims. As long as you can evidence it properly, you'll get a decent hearing. But it all comes down to,
we had an experience yesterday in court where actually it felt quite reassuring that when we were asking for recovery of certain documentary evidence in a case where we have concerns around inflated hire periods and and fraud issues in the background, that we were pushing at an open door when we went into court and asked for it. The judge was very much on board. So yeah, I just wondered if perhaps we were seeing things a little bit more favourable to us. So I think we just have to keep fighting the good fight, don't we?
I think so. And we're getting a wider range of sheriffs now as well, part-time sheriffs who are coming from, a lot of them are coming from the kind of backgrounds that we're coming from, legally speaking, and they will know these issues and know what to look out for. So yes, hopefully things are changing. I'm not sure if there's been any questions in the chat function.
Yeah, Angus, I can perhaps help you with that. I don't know what access you've got to on screen, but there's a couple of questions have come through. First one's from Michael Lang. If you're unhappy with a medical report from a pursuer, are you entitled to ask questions of the expert to challenge their conclusions pre or post litigation?
Well, you wouldn't ask the expert directly, but you would go back to the pursuer solicitors with any of those questions that you have. I know there's procedure in England for doing that. It's not quite the same here, but you are absolutely entitled to go back to the pursuer solicitor and ask any questions. For example, if there are gaps in the history presented of their previous accidents which have been explored fully, you're entitled to do so. When it's litigated, you're more likely going to get your own medical expert and examination of the pursuer. But pre-litigation, I mean, your hands are tied to an extent, so you have to go back and ask these questions. So keep a good record of your correspondence. My advice is always to appear reasonable. Set out why you have concerns or you want more information quite clearly in your correspondence, because if they then go on to litigate without addressing those concerns, we can maybe use that for arguments further on down the line once the case is concluded, to argue that there's unreasonable conduct or there had been premature litigation, for example, and we can make the necessary expenses arguments. But yes, there's no formal set procedure for doing that if that's what the question's directed at, but there are ways around that.
Thanks, Angus. The second question is from Julian Chenery. Does the fact that we can have remote examinations take place lead solicitors to using experts down south that insurers across the UK might have more concerns about or have links with those firms of solicitors?
I don't think I haven't noticed a massive trend in that regard. I'm not sure if you have, Stephen. But yeah, I mean, there is a potential for that, I suppose. But the experts we're seeing are usually, or at least they claim to be, based in Scotland, and we haven't seen that trend occurring yet.
Actually, I think that this is not something that comes from remote examinations. I think it does come from certain firms using certain experts, but their modus prior to the pandemic would have been to invite that expert up to a hotel room and get them to do 40 examinations on one day and prepare fairly pro forma reports that were of fairly poor quality. And so the fact that they can do those online, I don't think it's simply a question of geography, not necessarily a question of them changing which experts they use. That's right, yes.
You will usually find if the firms who do that sort of thing again are usually the firms that, like Stephen's saying, they will see a number of claimants during a day if they visited up north, and that's the type of firm that are usually on our radar anyway, because it's the type of firm who are farming out these and dealing with these personal injury claims, and a lot of them are fraudulent. So that'd be something that maybe would be a red flag to us.
Mark O'Reilly has queried, in terms of threatening the disapplication of quox to prompt abandonment, are we able to try to force a hand by providing damning evidence be flagged to the pursuer's agents as soon as possible? What sort of tactically would you recommend there, Angus? Is that somewhere where you would want to get it out early so that we couldn't be accused of having sat on it? And allowed costs to grow?
Often that will be the case. It depends on whether, say, for example, if you have somebody claiming ongoing symptoms and you know that they're going to get an updated medical report, an addendum report, and you may in those situations have surveillance, for example, and you want to sit on it to see exactly what further fraud or lies this person's going to come up with. So it'll be even more damning when you do present that evidence. But quite often you will just want to, once you have completed your investigations and you have that damning evidence, it's worth presenting it in pre-litigation if that's appropriate. It depends on the circumstances. Presenting it as opposed to thinking you should keep your powder dry, because it might encourage abandonment, or it might encourage just for the solicitors just simply to withdraw if they know that their client's lying to them, and the claim might not even get off the ground. So tactically, yes, it can be an appropriate way to proceed.
And maybe just to finish, Angus, our colleague Mark Morton has suggested we might want to just quickly explain how we could do a recovery of property, like a specification of property, and what that might cost. As he obviously can see that that's a good way of getting to a bottom of the truth where claims are being made in respect of property losses.
So in terms of cost, does he mean, I'm not sure Mark just means in terms of using the specification of property procedure and then recovering the evidence?
I think from a client's point of view, they would want to know if they were going to go down that route and instruct you to do so, what sort of costs we would be looking at. So, I mean, so I can perhaps answer that. That obviously where the specification of property itself is a document that we draft and lodge in the court with a motion, with an application for it to be granted. If it's unopposed, it'll go through fairly swiftly within the week or so, and it's no more than maybe a couple of hours of time that need to be spent on that. Obviously, if it becomes an opposed motion, then you're looking at a hearing and then having to convince a judge to order that. So that's going to increase your cost, and it's a little bit how long is a piece of string, depending on which court you're in. But beyond that, then the court order gets served once it is granted, and again, that process shouldn't really be particularly lengthy or costly. By that point, you really kind of are looking into the whites of their eyes and saying, do you actually have genuine evidence to support this claim or not? And mostly by that point, you will have flushed the issue through, and they will potentially have already disclosed it to you. So not necessarily a particularly costly exercise, but one where it really helps to call out a claimant that you have suspicions about.
Yes, absolutely. More often than not, it won't be excessively expensive to go through that. I mean, it's essentially the same, similar to recovering medical records, for example, if there's no opposition to it. So it's definitely an option to consider on appropriate cases. It's not going to break the bank, and it's going to be worth it economically.
And I think one final point from our brand new trainee, Shan Keddy, in the team. She's saying that where we mentioned that firms, from our experience, have a tendency to deal with fraudulent claims, do we think they're doing so knowingly, or that they just take on cases without having the potential, without having the opportunity to do proper checks on them? As I said, Shan is brand new, so nice and green, and not quite as perhaps jaded as the rest of us. Shan, the short answer is there are some dodgy firms, and there are some firms that aren't dodgy, and but there are some firms that aren't dodgy that do sometimes get sucked into dodgy claims. But you'll learn very quickly which firms have got red flags all over them.
That was a very appropriate answer, Stephen. That was good. And nobody's been defamed, which is the important thing.
That's why I answered it, to stop you doing the defamatory stuff. Anyway, thanks for the questions.
Thank you very much, everyone. Thank you all for attending. If there's anything that comes up that you think of that you didn't ask during the question and answer session, feel free to drop me an email. It's agi@bto.co.uk, or any of the team will be happy to help. Other than that, I hope you all have a pleasant week and a long weekend if you've got one, and hopefully we'll be in touch and we'll see some of you very soon. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.